Connecting contract types to real estate practice. So far in this chapter, you have focused on when a contract is valid and how it is created through offer and acceptance. The next step is learning how the law classifies contracts. These classifications are not just labels from a law school exam. They tell you whether a contract must be written, how it is formed, who is bound, and whether performance is complete or still in progress. In a single Arizona real estate transaction, the same contract can be written, express, bilateral, and executory today, then become executed after closing. Understanding these labels helps you explain documents to clients, recognize hidden risks, such as implied agency, and spot when someone is trying to make unilateral changes that are not legally effective. Oral versus written contracts. A contract may be written or oral. Parole. The law recognizes both, but real estate is heavily driven by the statute of frauds, which requires many agreements to be in writing to be enforceable. A parole contract is any contract or modification that is not fully in writing. It may be entirely oral, or partly written and partly spoken. In general contract law, many oral contracts are valid and enforceable. You can hire a painter with a handshake, agree to buy a used bike verbally, or promise to pay a friend back for a small loan. In real estate, however, the rules tighten. Most states, including Arizona, require that listing agreements, purchase contracts, and leases of more than 1 year be in writing to be enforceable. An oral 6-month residential lease can be valid and enforceable. An oral 2-year lease usually cannot be enforced in court, even if everyone remembers the terms. Similarly, an oral promise to pay a sales commission is not something a broker wants to rely on. Arizona practice examples show why written terms matter so much. In one scenario, a buyer wrote a purchase contract stating that earnest money would be wired, and the seller later issued a cure period notice when the wire did not arrive on time. If the buyer needed extra time because the funds were coming from another country, those terms belonged in the written contract. The cure notice was proper because the buyer failed to perform as written, not as understood. In another case, a buyer's offer form required an AAR loan status report LSR to be attached. The buyer submitted the contract without attaching the LSR. The seller nevertheless signed and accepted the offer. Later, the seller tried to demand an LSR with a cure notice. Because the seller accepted the contract as written, the seller effectively waived the written LSR requirement and could not cure notice the buyer for something not actually in the final written agreement. The written contract, not the missing form, controlled the relationship. These examples and Arizona's statute of frauds point to a simple rule for real estate professionals. If it matters, get it in writing, in the contract, before it is signed. Oral side promises and understandings are dangerous, especially when the statute of frauds says only written contracts are enforceable. Express versus implied contracts. An express contract is one where all essential terms are clearly stated and agreed to, either in writing or verbally. The parties explicitly set out their agreement. A signed residential resale real estate purchase contract between buyer and seller is an express contract. A verbal 6-month lease, where landlord and tenant clearly agree on the rent, dates, and property, is also an express contract. The terms are stated even if not written. Miguel buying his first home is a classic express contract example. He signs a purchase agreement that identifies the property, price, closing date, financing terms, and contingencies. The seller signs too. Offer, acceptance, consideration, mutual assent, capacity, and lawful purpose are all clearly spelled out. That is an express contract. An implied contract is not explicitly stated, but is inferred from the conduct of the parties and the surrounding circumstances. The parties do not sit down and spell out each term. Instead, the law recognizes an agreement because of what they did. There are 2 flavors of implied contracts. Implied in fact, the parties' behavior shows a mutual understanding, even though they never spelled it out. Implied in law, quasi-contract. There is no true agreement, but the court imposes an obligation to prevent unjust enrichment. When you drop your car off at a repair shop, you generally do not sign a full contract each time. By handing over the keys and asking them to fix a problem, you imply that you will pay a reasonable fee when the work is done. The shop accepts the car and performs the work, implying that they will charge a reasonable price. Their conduct creates an implied-in-fact contract. Another implied-in-fact example is getting your usual haircut. You sit in the chair, the stylist performs the service, and you pay at the end. No one recites, "I hereby agree to pay you for this haircut," but everyone behaves as if that agreement exists. In real estate, an implied agency relationship can arise when an agent performs services for a buyer without a written agreement, such as regularly showing homes, advising on price, or negotiating terms specifically in the buyer's interest. Even without a signed buyer-broker agreement, the agent's conduct may create an implied agency, with full fiduciary duties and potential liability. Implied in law, or quasi-contracts, are different. They are not true contracts, because there was no mutual agreement at all. Instead, the court imposes an obligation so that one party does not unfairly benefit from the other. Imagine you choke in a restaurant and a doctor rushes over and performs the Heimlich maneuver, saving your life. You did not ask for the service or agree to pay, but you unquestionably benefited. A court is likely to require you to pay a reasonable fee under an implied-in law theory to avoid unjust enrichment. The key takeaways are that express contracts are clearly stated agreements, while implied contracts arise from actions and circumstances. Real estate professionals should avoid unintentionally creating implied agency. A clear written agreement protects both the client and the agent and satisfies Arizona rules requiring agency relationships to be properly documented. Arizona examples of express and implied authority. Arizona practice also illustrates implied authority within written relationships. In one case, a seller and listing agent signed a 90-day listing agreement. The designated broker initialed the listing 3 days later, as required by statute for review. The question was when the listing term began. The answer: the 90 days started when the seller and listing agent signed, because the agent had implied authority to bind the brokerage to listing agreements, and the statute only requires the broker to review and approve within 10 days for administrative purposes. The listing was an express contract, and the agent's authority to enter into it was implied from the brokerage relationship and Arizona law. In another case, a fax notice of cancellation was sent to the listing broker on a Sunday night, the last day of the inspection period. Under the contract's express terms, fax delivery was deemed effective when sent. Even though the broker did not read the fax until Monday, the notice was treated as delivered on Sunday. The written contract controlled when notice was effective. There was no need to guess about implied timing. These examples underscore how express contract language interacts with implied authority and conduct in Arizona transactions. What the contract says about delivery, authority, and timing usually governs. Bilateral versus unilateral contracts. A bilateral contract is a two-sided agreement. Each party makes a promise to do something in exchange for the other's promise. A unilateral contract is one-sided. One party makes a promise that becomes enforceable only if the other party chooses to perform a specific act. Most real estate contracts are bilateral. In an exclusive right-to-sell listing, the broker promises to use due diligence to market the property and cooperate with other brokers, and the seller promises to pay a commission if the property sells during the listing term. In a purchase contract, the seller promises to convey good title, and the buyer promises to pay the purchase price. Each side's promise is consideration for the other's promise. A unilateral contract involves one promise and one performance. An option to buy is a classic unilateral contract in real estate. The optioner owner promises to sell the property on agreed terms if, and only if, the optionee, potential buyer, exercises the option within a set time. The optionee has no duty to buy. They merely have the right to buy, but the option or must sell if the option is exercised. Until that moment, only one party is truly bound. Outside real estate, unilateral contracts show up as rewards and contests. A sign that says, "Lost dog, $5,000 reward if found," is a unilateral offer. The dog owner promises to pay the reward if someone performs the act of returning the dog. If you find the dog and call the owner must pay. Until that act is performed, no one is obligated to do anything. Unilateral contracts are also used for promotions, such as a restaurant promising a free meal if you finish a 5-pound steak. The restaurant promises the reward. You only incur obligations if you decide to perform. Unilateral actions versus bilateral agreements in Arizona practice. It is crucial not to confuse unilateral contracts with unilateral attempts to change a bilateral contract. Once a bilateral contract exists, one party cannot unilaterally change its terms. Arizona cases show this in practical ways. In one scenario, a buyer submitted a BINSR requesting repairs. The seller replied, "I refuse to do any repairs," and the buyer has 1 day to accept or I will cancel. The underlying contract gave the buyer 5 days to decide after receiving the seller's response. Because both parties had already entered into a bilateral purchase contract, the seller could not unilaterally shorten the buyer's 5-day decision period. The new 1-day term was ineffective. The original 5-day contract term controlled unless both parties signed a written amendment. In another situation, a seller wanted to cancel a 1-year listing agreement 3 months in, simply because she was unhappy. A listing is a bilateral contract between the seller and the brokerage. Unless the listing agreement or law gives a unilateral escape right, for example, for material breach, cancellation requires mutual agreement between seller and broker. The seller cannot simply announce, "I cancel," and end the contract. At most, she can request a mutual release. Similarly, using ambiguous language like "close of escrow" on or before April 27th can create confusion. When a buyer demanded to close early on April 25th, based on the "on" or "before" language, the seller refused because his moving date was tied to April 27th. The only specific date both parties actually agreed to was April 27th. Without a mutual written amendment, the seller could not be forced to close on April 25th. The better practice is to choose one clear closing date and amend it by written agreement if both sides want to move it. These Arizona examples show that while unilateral contracts are valid in specific contexts like options and rewards, unilateral attempts to alter bilateral real estate contracts generally have no effect. Changes require a new meeting of the minds. Executed versus executory contracts. An executed contract is one where all parties have fully performed their obligations. An executory contract is still in progress. One or more obligations remain to be fulfilled. Some contracts move from executory to executed in a single moment. If you walk into an electronics store, pay $500 at the register, and walk out with a television, the parties' promises are made and fully performed in one transaction. The contract is executed immediately. Real estate contracts, however, are almost always executory for a period of time. When a purchase contract is signed, the buyer has not yet paid the purchase price, and the seller has not yet delivered the deed. Inspections, loan approvals, title searches, and closing tasks must be completed. During this period, the contract is executory, binding, but not yet fully performed. Once the deed is delivered and the money changes hands at closing, the purchase contract becomes executed. A residential lease is another executory contract. The tenant agrees to pay rent monthly and follow lease rules. The landlord agrees to provide possession, maintain the property, and honor the lease term. Those promises unfold over time. When the lease term ends, the tenant moves out, and all rent and obligations are satisfied, the lease is fully executed. The case of McDonald versus Hewitt highlights the importance of distinguishing between executed and executory. Nelson agreed to sell timber to McDonald, with payment to occur after the timber was cut, measured, transported, and delivered. Nelson hired Hewitt to move the timber. Hewitt later sold the timber to someone else. McDonald argued that he had an executed contract and already owned the timber. The court disagreed. Too many steps remained: measuring, transporting, and final payment for the contract to be considered executed. It was still executory, meaning title had not yet passed. McDonald's remedy, if any, lay against Nelson for failing to perform the executory contract, not against Hewitt as a stranger to that contract. In Arizona, real estate transactions, the question, is this contract executed or executory, frequently determines what remedies are available. For example, if a buyer cancels improperly while the purchase contract is still executory, the seller may keep earnest money or sue for damages. Once the contract is fully executed and the deed delivered, the relationship shifts into post-closing rights and warranties. The purchase contract itself has been performed. When delivery turns an offer into an executory contract, delivery of acceptance is the bridge between no contract and an executory contract. In one Arizona example, a buyer sent a counteroffer to the seller. The seller signed it and handed it to the listing agent, instructing the agent to deliver it to the buyer. Before the listing agent could deliver the signed counteroffer, the seller changed his mind and directed the agent not to deliver it. Under the language of the AAR purchase contract, acceptance becomes binding when it is both signed and delivered by mail, fax, email, or in person, and received by the appropriate broker. Because the signed acceptance never left the seller's possession, delivery never occurred. There was no contract, so the seller could still withdraw. If that same listing agent had been a dual agent representing both parties, acceptance might have been deemed delivered as soon as the agent had the signed document, because the dual agent is considered to hold it on behalf of both sides. In that case, the contract would have flipped to executory the moment the dual agent received the signed counteroffer. This shows how delivery rules, agency status, and contract language combine to determine when a contract becomes an executory, binding agreement rather than just a signed but undelivered document. Putting the classifications together in real estate, most residential Arizona purchase contracts you work with will share several of these classifications at once. A typical AAR purchase contract is written because Arizona's statute of frauds requires real estate contracts to be in writing to be enforceable express, because the terms are clearly stated in the document and agreed to by signatures. Bilateral, because both buyer and seller make promises to each other executory, from the time of contract formation until closing. When it becomes executed, other documents in a transaction may be unilateral, such as an option or reward for performance, or may involve implied obligations, such as implied duties under an implied agency relationship. A short-term verbal lease may be an express oral contract. A handshake, promise to pay a commission without a written listing, may be valid in general contract law, but unenforceable in real estate because of the statute of frauds and licensing rules. Knowing how to classify a contract allows you to answer client questions like, is this binding yet? Can they back out? Do we need it in writing? And are they allowed to just change that? With confidence and accuracy. Review summary. In this section, you learned how contracts are classified along several dimensions. Contracts can be oral or written. While many oral contracts are valid, real estate contracts that create or transfer interests in land generally must be in writing to be enforceable under the statute of frauds. Contracts can be express, where all terms are clearly stated or implied, where agreements are inferred from conduct or imposed by law to prevent unjust enrichment. You saw how implied in fact contracts arise from patterns of behavior, such as repeated services, and how implied in law, quasi-contracts, allow courts to require restitution even without a true agreement. You also examined bilateral and unilateral contracts. Bilateral contracts involve mutual promises, such as most purchase contracts and listings. Unilateral contracts involve one party's promise in exchange for another party's performance, such as options and rewards. You learned that while unilateral contracts are legitimate in their proper context, unilateral attempts to change the terms of existing bilateral contracts, such as shortening inspection time or canceling a listing without cause, are generally ineffective without mutual agreement. Finally, you distinguish between executed and executory contracts. An executed contract is fully performed. An executory contract still has obligations left to fulfill. Most real estate contracts are executory from the time they are formed until closing or lease termination, at which point they become executed. Arizona examples of delivery, fax notices, and broker review helped you see how a contract moves from no agreement to executory to executed, and how disputes often hinge on timing and classification. Discussion: how can understanding the difference between express and implied contracts help an Arizona real estate agent avoid unintentional agency relationships and liability? Suggested answer: when an agent understands that an express contract requires clear, stated terms, while an implied contract can arise from conduct, they are more likely to use written buyer-broker and listing agreements consistently rather than relying on casual conversations. This awareness helps the agent realize that repeatedly showing properties, advising on price and strategy, or negotiating on a buyer's behalf can create an implied agency relationship even without a signed agreement. By recognizing that their conduct can create duties and potential liability, agents can deliberately document relationships, clarify who they represent, and avoid accidentally taking on fiduciary obligations to someone who has not formally engaged them. Closing remarks. Classifications of contracts might sound abstract, but in real estate, they are deeply practical. Whether an agreement is oral or written, express or implied, bilateral or unilateral, executed or executory, affects enforceability, remedies, and risk. As an Arizona licensee, you work every day with written, express, bilateral, executory contracts shaped by the Statute of Frauds, Article 26, and AAR forms. By mastering these classifications, you gain the vocabulary and insight to explain contracts clearly to clients, spot problems early, and know when to bring in legal counsel. In the next sections, you will build on this foundation by exploring specific real estate contract clauses, obligations, and default remedies, always grounded in the classifications and principles you have just learned.